Okay, our next speaker I've not met. Here comes Brian. I would think we could pick him out of the crowd, though, not because he's from Oklahoma, but because he's the three-time Oklahoma Karate Association divisional champ back in the 90s. He's an Oklahoma powerlifter, and he's a trial lawyer. He's here today to talk to us about distracted driving and case values. Brian Mincher. Brian, nice to meet you.
Thank you very much. Well, we're a little bit technology-driven in this presentation, so I have Sarah Valadares with me, and if anything goes wrong, I'm blaming her completely. Let's get rolling.
Sweet like honey to my soul, sweet you rock and sweet you roll. Lost for you, I'm so lost for you. Oh, when you come crash into me. Come on down, I wanna meet you. Come on down, I wanna meet you. Come on down, I wanna meet you. I wanna meet you. I wanna meet you. All you angels gather round, showing all your brothers down. All you angels gather round. I wanna meet you. I wanna meet you. Yeah. I wanna meet you.
Oh, damn. Oh, damn. Oh, damn. Oh, damn.
All right, welcome to my presentation on distracted driving. Thank you all very much for having me here. We've got some more materials in the written material that you have than what you're going to see up here. Some of this stuff, the statistics and whatnot, we're going to gloss over a little bit and not get into too much of the details because we are limited on time here. However, let's go back to that one, Sarah. I want to bring your attention to a couple of things. First of all, you're going to see some stats in here as we go through, and it's in your materials about what percentage of cases involve distracted driving. Well, I'm going to tell you right now, those statistics, as far as I'm concerned, are hogwash. And I'm going to try very hard, my good friend Paul's here to tell on me, I'm going to try very hard to keep my language clean here today. But it's a bunch of baloney to think that the low percentage that we see in these stats of who was distracted is reality. Because think about it. If you're paying attention, you've got your hands on 10 and 2, and you're doing everything your driver's ed instructor told you to do, you wouldn't have run into the plaintiff. We wouldn't be here to begin with. Start off every one of your cases as if it's a distracted driver case. Make them prove to you that it's not. Go in with that mentality and see what happens and how it changes up your practice. In looking for distracted driving, there's 3 different types, broadly speaking, that you're going to be looking for. We've got your visual distractions, taking your eyes off the road. Raise your hand if you drove to get here or drove to the airport to get here. All right. Raise your hand if you saw this. All right. And you saw it more than once. You saw it more than twice. The reality is, just like all of you, I drive Texas roads every single day. I put my wife and kids out on Texas roads every single day. And as I am looking around when we are driving, I see people on phones. I see people on laptops sometimes. I see cops on laptop all the time. Love that one. Just fabulous. Fabulous. That is a visual distraction. What else is it? It's also a manual distraction. Taking your hand away from the wheel, handling that phone. It's also a cognitive distraction. You are taking your mind away from your task. The cell phone, I love. It's fabulous because it covers all 3 of those bases. However, I don't want us limiting our thinking. Looking at the radio is a distraction. Looking out the window. Looking at the pretty girl driving past you in the lane next to you. Anything that prevents you from being in that perfect 10 and 2 driver's ed position is doing what? They're falling below the standard of care that they themselves would expect of other drivers on the road. Settlements from distracted drivers cases. My guess is I'm in a room full of people who try to make their living by suing folks. Am I? We in business here? We want to make money? All right, we want to make more money? Would we like to make more money on the exact same number of cases that we're working on right now? Heck yeah. No extra overhead here, and yet you're going to have extra to the bottom line. Doesn't get much better than that. Examples of visual distraction here. Who here has not either been the mama or been the child in this situation? We've all been there. It's really cute, isn't it? Oh my God, until she's petting that dog instead of looking at your back bumper. It's different examples. Look for these. They exist in every one of your cases. Makeup. I love that one. I cannot tell you how many times my mama nearly killed me in the mornings taking me to school and putting on her makeup. All right, and I love this last one. It's cognitive distraction here, just daydreaming. There was a time when people would daydream in the car. I haven't seen it in a long time because people are looking at their phones. I love this one. 52% of young drivers admit they have talked on their phone while behind the wheel, which lets us know that 48% of young people are liars. Let's go to the next one. Similar numbers of liars here. 34% admit they've texted. Anybody believe that? These are the official stats. These are what people will agree to. These is what people admit to. What do they actually do? We all know. A little over half claim it's easy to text and drive at the same time. They're actually telling the truth. They're wrong, but they're telling you the truth. They really think it's easy to text and drive. And it is, right up until they drive into the back of Tom's bumper. Similarly, about 3/4 of them are confident they can text and drive, and again, they're wrong. All right, we're going to look at a couple of different cases here, and I will tell you the first one is Mr. Riley Lazard. He was, you'll see some of the facts will come out as we go through this. Riley's at the kind of the bigger end of the spectrum, and we've got another one that's kind of at the smaller end of the spectrum. Riley was driving one of these work convoy trucks, protecting a work crew. And one thing that drives me crazy at these seminars is all I ever hear about is the case where the supermodel got her face ripped off and the guy got up there and somehow managed to get policy limits on that case. Well, no kidding, all right? So we're going to start off with my face ripping off case after I down-talked it, and then we're going to talk about some cases that I guarantee everybody's got a lot of. So here's the sexy case. We go out and take pictures, and what do we got pictures of? What does that look like? That's rims and tires. Used to be attached to trucks, no longer. That is the back of the vehicle and the safety trailer that Riley was actually parked in. Go to the next one. That flashing arrow at the top we referred to throughout the course of the case, throughout the course of the investigation and with all the witnesses as a 15-foot-tall do not hit me sign. It was flashing. It was supposed to alert drivers on I-35 to get over, and Riley was there protecting a work crew. That trailer, or what used to be a trailer there, that yellow mangled device in the back, that is a safety trailer that is probably the reason why we're not talking about a death case here today. Hopefully it shows up on here in the darkroom. You can see very easily. That used to be the back glass of the truck. It's not there anymore. It's scattered out over the back of the bed of the truck. That right there is 3/8-inch corrugated steel, actually not corrugated steel, diamond plate steel. If anybody wants to get into the physics involved in this case, it's got some pretty interesting numbers when you run a 4,000 or 5,000 pound vehicle into a fixed object at 73 miles per hour. You can get into some really interesting numbers with your experts. Here's the truck that hit Riley. Somehow or another, this fella managed to run into the back of Riley without ever hitting his brakes, without ever swerving or doing anything to avoid the impact. Struck Riley at exactly 73 miles per hour. Keep going. Now here's a photograph of that same truck, and obviously it's upright here. This is not at the scene of the accident. This is at the scene where we went and did an inspection. I strongly encourage you, when the cases have this kind of damage, when you can afford to do so, when it is justified, hire proper experts, get out there, look at these things yourself. There are things that I learned in my inspection with this particular truck, going out with Will Miller from Crash Analysis, that I could not possibly have learned in any other way besides physically going out and crawling around in there. For instance, this truck has a black box in it. Will and I sat in that truck, pulled out a pocket knife, and cut the box out. I watched him download a bunch of zeros and ones. Meant very little to me. He, however, turns those zeros and ones into a report that you're going to see some excerpts from later that turned this case into a substantially valuable case because it proved some specific safety violations that Mr. Rowland, I think his first name was Eric, that Mr. Rowland had violated some safety rules that he knew better than to do. One of the things that I learned that I couldn't have otherwise known, and I thought it was neat, and I think everybody here ought to know it. There is a device in every vehicle, at least every modern one, called a pretensioner. Anyone ever heard of a pretensioner? Few hands. Okay. We're in a room full of car wreck lawyers. We all need to know these things. This is what we're here to learn. I didn't know it until this case. And I've been doing this for 15, 16, 17 years before this. Pretensioners go off. They're an explosive charge. They go off and zip up the seatbelt in the same way that an old yo-yo style fishing reel, automatic fishing reel would do. The pretensioner on this had gone off, as it does in every wreck. Well, what was interesting about it, though, is that pretensioner sucks up and tightens up as much as it can. Well, in this case, it sucked up and tightened up a seatbelt that was not buckled. And we know that because when we reach into the truck, the seatbelt is tight. It was as hard as touching the side of this podium. That's how much tension was on there, which is how we knew before we even got into the electrics. With absolute certainty, this guy's violating the number one safety rule within their own materials, wearing a seatbelt. Okay, something is going on here. We got to look into this. We send out discovery. We find out the guy was on the phone. Not terribly surprising, given what we all know in here. Let's go to the next one. Here's young Riley. Good-looking kid, makes for a good damage model. Unfortunately, that matters in this world. Go to the next one. That is what caused that back window to get busted out. That's the back of his head. Yes, ma'am, right here. Lucky, handsome fellow that he is, he's got plenty of hair to cover that. But it's pretty gruesome. Goes in the case, and it's something that, something the insurance adjuster's not real crazy about. All right, so once we have some good evidence, we have a very good feeling like we've got a distracted driver here. How do we mechanically, nuts and bolts, how do we go about proving this up and increasing the value of our case? We took the deposition of Greg Moran, who was the safety director, and we took the deposition of the driver separate. Go ahead and play, Moran. Okay, sir. What is your current job title?
Vice President of Risk Management for Kaufman Tire.
Can you tell us what Exhibit 7, which is Kaufman number 87, what that is?
The health and well-being of our associates is a top concern of Kaufman Tire. This acknowledgement outlines basic safety rules that all associates are responsible for adhering to. Additional specific safety requirements may be communicated by your supervisor. Failure to follow the safety guidelines may result in disciplinary action up to and including termination.
First line, the health and well-being of our associates is a top concern of Kaufman Tire. Do you believe that to be a true statement?
In the general sense, yes.
And do you personally believe that, just in your own heart?
In the general sense, yes.
So now we've got them committed, right? Safety. Lukewarm, it's a big deal, right? Well, let's see what Mr. Rowland thinks. Did you let Kaufman Tire know that you were having an issue with your inner ear?
Yes, sir.
When did you let them know that?
That morning before I drove to work, sir.
Did you work all day the day of this crash?
When I went to the doctor that morning, sir, so I'd be alive. I told you I worked all day because it's 90 miles from Waco to, isn't it? So you got an hour and a half drive to work after going to the doctor. So no, sir.
Right.
I went there afterwards.
Okay. So when you were talking to Steve Sebastian, were you still at the doctor's office?
I don't know if I pulled out of the parking lot or if I was down the road or... No, sir, I couldn't answer that.
Were you still in the Waco area?
Yes, sir.
All right. Exhibit number 12. What's that say across the very top, sir?
The health and well-being of our associates is the top concern of Kaufman Tire. This acknowledgement.
Let me stop you there.
Yes, sir.
And then the title of the document is what?
Safety acknowledgement, sir.
Okay. Were you concerned about your safety whenever you were talking to Mr. Sebastian from Waco?
Just worried about my job.
Good lesson to be learned there, the distinction between those two. One of them was on video, right? The other one we only had audio of. Unfortunately, I don't have video for that one. I wish I did. When you can, always get the video. We're going to continue to hear from Mr. Rowland as we go through this for the next few minutes. And his body language, I think, is just priceless. We included a lot of this material that you're seeing right now from these two guys as a part of a presentation that we made at mediation. So what you're seeing here is at least a part of what our mediation presentation was. And so imagine and I know there's some folks in here that have sat next to adjusters. I spent 12 years sitting next to those fine folks whenever I was on the defense side. And I know from a lot of experience what makes them really, really uncomfortable sitting in that room. And so we kind of approach it in an effort to make them as uncomfortable as possible. Imagine sitting in a room having to put some dollars and cents to this situation, where now we've got a guy who, frankly, I don't think makes a real good witness. He's not terribly sympathetic. He's going to go on and tell us what a great driver he usually is here in a little while. But this guy actually calls his bosses and says, look, I am feeling poorly enough. I'm at the doctor right now. I can't go to the office today. I can't go into work. And they say, get your ass to work anyways. Well, now we've not only got a distracted driver and possibly a bad actor with Mr. Rowland, now we've got a really dangerous company out there. A company that is absolutely, without doubt, putting their company profits over the safety of their own employees as well as your safety and those of your families. Just like it's putting those profits over the protection for the jurors' families. All right, let's go to the next one. And if we look down at the charges, who got a ticket there?
Unit 1, so that would be Alec Rowland.
And what does it look like they gave him a ticket for?
Failed to control speed.
Do you know what happened with that ticket for failed to control speed?
I do not.
Is there any company policy that you're aware of as far as like what happens with tickets that happen in a work vehicle?
No, there's no policy on it.
All right, okay. So driver of Unit 1 failed to control his speed and steered to the right just before striking the right rear end of Unit 2 with his vehicle's left front end. Do you have any direct knowledge as to that statement?
I was told, prior to the police report, I was told that he just hit the vehicle on the rear.
Okay, and then where it says Unit 1 overcorrected.
Unit 1 overcorrected to the left and rolled onto its right side.
Have you seen the photographs of your Kaufman pickup on its side?
Yes, I have.
Okay, so it looks like that's a true statement as well, correct?
Yes.
And Unit 1 came to rest.
Unit 1 came to rest facing east across both southbound lanes of traffic.
Quote, Unit 2 drove forward.
Unit 2 drove forward at the right approximately 50 feet and came to rest on the right shoulder of the road facing south.
All right, and then, quote, the driver of.
The driver of Unit 1 stated that he had become dizzy because he was driving and did not see Unit 2 in the time to avoid a collision.
Oh, that's right. All right. So, in real life, we just deposed the safety director, and on a different day, we just deposed the driver. We're cutting it up for purposes of kind of presenting the story here today. Let's go back to Roland. So here's an excerpt from the crash report, and it shows a crash time of 17:35, which hopefully everybody in this room knows is 5:35 in the afternoon, and that's important because, keep going, lo and behold, dun, dun, dun. What we got there? Cell phone records. Go on. In particular, we have cell phone records indicating phone calls coming in and going out between 5:08 and 5:46 on a day when we know the crash occurred at about 5:35. Next one. In addition to the cell phone calls, he was also cell phone texting. Guy's pretty impressive, frankly. 454, 531, 532, 533, texting, sending, receiving, smacking into the back of Riley. 2 minutes later, that's what's going on. See, he's driving in the back of Riley's truck. Go ahead.
All right, I'll show you now what we've marked as Exhibit 8. If you take a look at the highlighted portion there.
Yes, sir.
Does that appear to be a phone call that you made at 5:28?
Yes, sir.
Would that have been within 10 minutes of this crash?
Yes, sir.
And you would have been on I-35 traveling southbound
Yes, sir.
behind the wheel?
Yes,
you
sir.
actively driving?
Yeah, so I said yes, sir.
Okay. And then I'm going to show you what we're marking as Exhibit 9.
This says I was on my cell phone. It's like 1 minute. Is that what that says? I don't understand these.
Yeah.
Is that 1 minute? So I was on it from 5:28 to 5:29.
That's my understanding, yes, sir.
If I was on it for a minute, does it just charge you for a minute automatically if you're on it?
Yes.
So it could have been 20 seconds.
He's going to charm his way out of this.
Yeah. And Exhibit number 9 that I've just sent you there, they're handed to you. Does that indicate that you were sending a text?
At what time, sir?
Read the highlighted section for me.
It says 5:31. A text was sent.
Okay. And can you hold that up for the camera? All right. And the crash report indicated that the crash time was 5:35, correct?
That's what the report said. Yes, sir.
Okay. And so we've got in Exhibits 8 and 9 evidence of a phone call and a text sent while you were behind the wheel within 10 minutes of the crash, correct?
Within 10 minutes of the crash, correct.
Do you think you were handling that truck in a safe manner at the time of the crash?
Size don't show up in transcripts.
In my opinion, I don't understand. I mean, I have a pretty good record, and I mean, I've been doing this for 21 years, driving the worst stretch of I-35 for 21 years.
I get that, and I appreciate it, but I'm not asking. The question is not, are you in general a good driver? If that was the question, the answer you just gave would be spot on. My specific question is, at the time of this crash, were you operating that truck in as safe a manner as possible?
I didn't have my seatbelt on, and it shows that I was running a few miles an hour over the speed limit.
So is that a long way of saying no?
To those two deals, no.
Okay. Why do you think, in your opinion, I'm asking for opinion, not fact, but in your opinion, why did this crash occur?
I mean, due to the facts, of the trucks, it looks like I ran into this pickup.
All right, here's some of the excerpts from the crash report, or not the crash report, but the experts report that Will put together for us. The highlighted section there indicates the speed of 73 miles per hour. Go to the next one. And then the conclusions page here kind of translates those zeros and ones into something that we can actually use. The conclusions was that he never hit his brakes, didn't have his seat belt on, made no corrective action at all, and did exactly what the photographs and crash report indicate, was paying attention to something other than the road, drove into the back of this young man at a very, very high rate of speed. Just keep going to the next one. All right, so we had 127,000 medical bills on this case by the time it was all said and done. We had some thoracic vertebrae injuries. After showing excerpts from the fine folks there at Kaufman Tire to their adjuster, and this is crucial, and being called to trial. This did not settle at mediation. We walked out of mediation, everybody flipping the bird to everybody else. We were at $500,000, they were at $200,000 or something to that effect. And well, I'm not going to move if you're not going to move. Well, to heck with you. Well, to heck with you. We'll see you in court. I think most folks in this room would probably be pretty excited to go down and present this kind of a case at court, especially with the idea of getting Mr. Rowland up on the stage and his supervisor, who thought it was a good idea to drag him to work and put all of us in danger. Well, guess what? All those things were working on the adjuster as well, which is why she ultimately rolled over and paid us $452,500 on Friday afternoon, which is when I settle all of my decent cases. So every case that I settle for any kind of good money is on a Thursday or a Friday afternoon when we've been called to court. Anybody else have that experience? If you don't, you should. If you don't have that experience, try more of your cases. Put the fear of God on them. Make them realize that it's a big deal whenever your case gets called to trial. Let's go to the next one. That's a settlement memo. Riley ended up getting a couple $100,000 on this deal after it was all said and done. Now, you may not have a lot of Riley Lazard cases in your inventory. Frankly, I don't have nearly as many of them as I would like. But I just about guarantee everybody in this room's got a lot of Jason Jackson cases. Go on the next one. See that bumper damage? In the words of my very first boss, good God, how many were killed? And if you're looking, don't squint. It's not there. There is no bumper damage. There is no PD at all. Did anyone in this room besides me ever get crappy offers on these low PD cases? Yeah, we all get it, right? This case here had, I think, about 13.5 in chiropractor meds. They never offered us more than $4,500. Do these numbers sound more familiar to everybody? All right. And everybody, raise your hand. I won't even look. Raise your hand if you would have settled this case for $15,000 and run away. All right, put them back down. The rest of you are lying. They didn't offer us $15,000. They never gave us the option to settle this case. Offered us about $4,500. We had nothing. It's a terrible case. There's no PD. Nobody could have been hurt in this sort of a thing. You didn't even break a bone. You didn't go get a surgery. You're in North Texas. Oh my God, what are you even doing taking cases like this? Well, they deny. Everybody gets those, right? Go to the next one. In her deposition. So, question, would it be correct to say that you were moving forward and heard the phone ring, looked over at the phone? Did you pick it up or did you just look at it? No, I picked it up. There it is, folks, smoking gun. The only thing about this case that is interesting even a little bit. Go ahead. So it's a handheld phone, so you need to hold the phone to your ear. Answer, yes. And did you put it up to your ear? Yes. And had you begun to say anything before the accident happened? No. Notice there's no video here. I don't even have audio to show you because just like all of you, I'm not spending the $25,000 or $30,000 that I spent on Riley's case on a case of this magnitude. And the reason I'm bringing them both up here is because I want to show you that the same principles apply. When you have a distracted driver, you're going to get more value on that case. You may have to go get it from the jury, which we did. After a 2-day trial, the jury came back and awarded us $58,921.94. How's that $15,000 sound now? So how do we find it out? How do we prove it up? We ask. We're going to fly through these. In interrogatories, and this is all in your materials, so we're going to fly through this. I'm not reading these. Ask for it in interrogatories. Ask for it in production of documents. Follow up on it. Ask them in admissions. Accuse them of these things in all of these paper forms. And then just keep flying through this. And then this too. This stuff's all in your materials as well. These stats here, these are things you can hit them up with in their deposition after you've accused them of being distracted. And when they start saying, oh, no, I wasn't distracted at all, and you say, well, then why did you run into the back of this person if you were doing everything properly? And then when you have the inevitable end of that conversation that shows that they either have to agree with you that they caused the wreck, or they agree with your facts but refuse to take responsibility, which is even better, then you've done your job. All right, last thing I'm out of time here. Thank you guys very much. Last thing I want to, a little parting shot here. I am in a room of what should be alphas. Everyone in this room should be the alpha male or the alpha female of their pack. These insurance companies are out there. I see some really smart folks in here that I know that used to work for them. They've got smart folks working for them right now. They are out there trying to knock down verdicts. They're out there working on the legislature. They're out there working on the public. Be a wolf. Be tough. Whenever you get to a mediation and you've got a case like Riley's and they offer you $200,000 or $250,000, don't think that's $250,000. Think that's $200,000 short of what that case is worth. Be willing to walk out of a mediation. Be willing to go down to the courthouse. You're not going to win every one of them. But if you go down there, if you develop a reputation of somebody who will take those cases to trial, you will, over time, develop the skills necessary. Come to things like this. Visit with people that know what they're doing. Go second chair a case with somebody. I'm looking around. I'm seeing talented people that I know in this room that I've tried cases with or against. They will help you. Go sit with them and learn how to be this. Thank you.